Hello, everybody, and welcome to our Getting Your Affairs in Order presentation with Elder Care Attorney Robert Slutsky from Slutsky Elder Law. We are happy that you're able to join us today so that we can serve as a resource to you and your families. We have three offices. One is in Malvern, one is in Plymouth Meeting, and the other is in Radnor. And we are seeing clients and their families in person again right now, or you can schedule a Zoom consultation, or as always, we do have phone consultations. Rob is able to help you out with Medicaid planning, special needs planning if you have a loved one with a disability. He can help out with all of your elder law needs, estate planning, any type of long-term care planning that you're doing, and anything pretty much under the elder law umbrella. Rob has been practicing for almost 30 years. So I like to tell everybody he is truly an expert in the field. We want this to be an interactive experience for you. If you can keep on your video, we would love to have you.
Hello.
We would love to have you participate in our presentation today and join in anytime. If you have any questions, you can use the chat or you can unmute yourself as well. Thank you so much. And I'll give the floor to Rob now so he can share a little more information about himself.
Terrific. Thank you, Heather. So Heather kind of said it. I've been doing this for almost 30 years. I have a private elder law practice. But in addition to that, one of the things I'm proud of is for the last 23 years, Montgomery County has had enough confidence in me to make me their solicitor. So I have represented the Montgomery County Office of Aging and Adult Services, now called the Montgomery County Office of Senior Services, since 1999. I do the protective services work for the county. And for my private clients, we do planning, helping people, the families through the long-term care continuum, dealing with long-term care costs, general basic estate planning, estate administration, guardianships. And we have a lot of clients with a family member who has a disability. So we do a lot of special needs planning as part of our elder care planning. So, you know, my perspective is a little different from some of the other elder law attorneys you may have spoken to, because for the most part, a lot of elder law attorneys, and rightfully so, focus on the asset protection side. And I do a ton of asset protection, but my perspective is a little bit more global, because when you've represented social workers for almost, for 23 years, they influence you in a positive way. So I have a lot of work with people with cognitive impairment. I do literally probably more guardianships than any lawyer you've ever seen or met. And so I have a slightly different perspective that includes protecting assets, but also is focused on the needs of the family. So one of the things that I have always felt since I started practicing elder law is that a power of attorney is a very important. Heather, do you want to mute everybody unless they're asking a question?
Sure.
What's a power of attorney and how is it used? And I think that's really an important factor in any estate plan, whether you're young, old, rich, poor. So now I'm going to, once again, I'm going to parrot what Heather said, which is, I love to see you. So if you could put on your cameras, if you have one, I don't care if you're having a bad hair day, I'm having a no hair day. Look, so don't worry about anything aesthetic. I want to see your faces. So number one, anybody got guts? Hi, Peggy. Anybody got enough guts to tell me what they think a power of attorney is? Any and all?
I think a power of attorney is giving authorization to someone you trust with your information.
That's a very excellent description. There's a little bit more to it, but that's a really good overall description. Not only are you giving them access to your information, but you're authorizing them to do things for you, both potentially medically and financially. So that's a good start. And that's where the next question comes in. When does that power of attorney work? Meaning, let's talk about the different parties so we can all know we're on the same page. So the person who gives away the power is called the principal. The person to whom they give the power away is called the agent. That's the person, you're my agent if I give power of attorney to you. So when can the agent start acting for the principal? again, I want you to raise your hand here. I'm going to ask you a question. And okay, Lisa, you actually, Beth, I'm sorry, you wanted to answer the question, so answer it.
I'm just remembering with my father, after he had a stroke, his,
Okay,
we already had it set up.
okay.
And
So your
it was,
position is, and because I was going to give you two options, Beth, and you tell me what you're thinking.
okay,
So the first option is it can be used immediately upon being executed by the principal. That means the agent can act immediately. The second option is the principal has to become incapacitated before the agent can start doing their job and helping them out. So who says number one, it's immediate? Raise your hands and turn on your cameras. Let me check the second screen. I don't see anybody on the first screen. Let me see. Does anybody think that it's immediate? So Elaine thinks it's immediate. Rebecca thinks it's immediate. Mary shaking her head no. Okay, Mindy is shaking her head no too. Okay. So most of you think that you have to become incapacitated before the power of attorney can be used by the agent. Is that what I'm getting? That most people think that? Terry doesn't think that. Terry thinks you can use it immediately.
I did.
Okay. You guys are talking to a lawyer. You know that, right?
Yeah.
Because that was a trick question. It depends on what the document says. You can have a normal, standard, general, durable power of attorney that is immediately usable upon execution, or you can have one called a springing power of attorney. And a springing power of attorney has a springing provision. And the springing provision usually says when I'm unable to manage my affairs, okay? Most elder law attorneys don't like springing powers of attorney. Can anybody figure out why that I, as an elder law attorney, would think that a springing power of attorney is not in my client's best interest? Yes, Beth.
they think they're great and they don't realize that they're incapacitated, or they become totally incapacitated. And how do they contact the person that's power of attorney? But like, if the person is senile and they're getting worse, they think I can still manage, and then they don't turn it over to who has the power of attorney because they think they're still okay.
Well, those are excellent observations. They are. I'm not sure that they necessarily address why. Well, actually they do. You know, you're right. But why wouldn't I like it? Why would I say, Beth, I'm going to recommend you do not have a springing power of attorney? Well, why do you have that power of attorney in the first place, Beth?
For somebody to take over when I can't.
Exactly. So what happens if I put up a nice big roadblock in the form of a springing provision? Does it make your agent's job harder or easier?
Harder.
Much harder.
Yeah.
Because, by the way, you've got 5 bank accounts and 3 stockbrokers accounts. And every single financial institution is going to have a different requirement to satisfy the provision that says, I'm incapacitated and Beth can take over. Why would anybody who actually read the power of attorney, because 99.9% of the time people don't read them and they just trust what the attorney drafted, even if the attorney doesn't really know what it says. So why would anybody want this kind of roadblock in front of their agent? Lisa, you going to say something? No? Why would I want to put this roadblock in front of my agent? Why would I want them to only be able to access my funds or talk to my doctors if I'm incapacitated? No thoughts by anybody? All these smart looking people here? Wait, Mary, you haven't said anything yet. Mary. You've got it. Mary, you're muted.
Maybe because you don't want the person to have the control right away.
Okay, now let's think about that, Mary. If I have 110% confidence in Heather's good judgment, and I've named her my agent, and I do, because Heather is a very responsible person. She would always do what's best for me. If I trusted Heather, why would I want to put a roadblock in front of her?
I don't know.
Yeah, it's really a hard question, isn't it? I think when most people are posed with the question, they're like, Why did my lawyer put that provision in? Because the idea here is when you're thinking about a bad situation where you can no longer manage your own affairs, and you're saying, look, I trust my spouse, my partner, my child, my nephew, my dear friend, my clergy person, whoever I choose, I'm putting them in there for a reason, because I believe that they have good judgment and would honor my wishes and do the right thing. So what I'm telling all of you is that if your power of attorney, and most don't, but there's a couple out there that do have a springing provision, you might want to reassess whether that's a good choice for you. Excuse me, because that could end up putting a situation where your agent can't do the things that they need to do for you in a timely manner. And I will tell you, as someone who just was in court a week ago Tuesday with a bank, and I had to educate them on not following judges' orders. Judges are pretty much taking the same position towards powers of attorney, where banks choose to say, well, we're going to have them looked over by our legal counsel, and we can't tell you when you'll get access to the account. So when you put more roadblocks, you give financial institutions license to create more problems for the people who are trying to help you. So think about that and review your powers of attorney. And if you don't have one, think about that if you want to draft one. Okay, but let's say you don't have a power of attorney. Let's assume you didn't do any planning, you didn't think ahead, and you become incapacitated. God forbid, you're in a car accident, you're sitting in a bed in a hospital unconscious. You didn't do a power of attorney. I'm your son, I'm your husband, I'm your partner, I'm your friend. How am I going to be able to manage your affairs now? What do I have to do because you don't have a power of attorney? How am I going to handle that?
First thing you do is call Rob.
Carl, I very much appreciate your confidence, and the check will be in the mail, buddy. Understand that Carl has been to about 15 of my presentations over the years. Well, other than calling Rob, which is always the right answer, other than calling Rob, what's Rob going to have to do for you if there's no power of attorney?
Get a guardianship.
Get a guardian. Who said that?
I did.
Lori. Hi, Lori. It's good to see you.
Nice to see you too.
Yes, Lori is correct. We're going to have to get a guardianship. And why would we want to avoid that? Well, let's talk about the interplay between powers of attorney and guardianship.
What?
With a power of attorney, I can choose.
Well, you don't have one at home?
Authority. Heather, you want to mute everybody?
Oh, really?
You're not able to? I'll just ask everybody who's not speaking at any point to mute their thing, because there's a lot of reverberation and
All you need
noise.
is
So if you prepare a power of attorney, or your attorney does, you can put in comprehensive authority for your agent to make medical and financial decisions for you. When you have to go to court to get a guardianship, there is the judge is constrained by the law. That means that there are certain things that you will not be able to do as a guardian, with or without court approval. But secondarily, even if you want to do something that is approved, you might need to seek court approval to do it, which means more time and delay and more cost. And by the way, what do you think is going to be a less expensive planning tool? Going to a lawyer and getting a 10-page document drafted, or going to a court and doing a legal proceeding? What do you think is going to be less expensive? It's going to be power of attorney. And by the way, when you have to go to court for a guardianship, the judge is going to choose your guardian. Sometimes they'll choose the person you would have chosen. Sometimes they will not. So when you are doing a power of attorney, you are taking control of your life, and you're saying, I trust this person, and here's the authority I'm going to give them because I want them to be able to help me immediately. And understand that a guardianship is going to cost lawyers' fees for someone who knows what they're doing, let alone someone who doesn't, is probably going to cost somewhere between $4,000 and $15,000. And that's a lot more expensive than your typical basic estate plan with a good power of attorney.
Can I ask a question?
Sure. Who? I can't see. Yes, Mary.
It's Mary Ellen. What are the pros and cons of having more than one power of attorney?
The only con is going to be family dynamic or, relationship. In other words, if you trust all of them and you feel that they will all get together, and there's no real downside to having multiples. The upside is if somebody is unavailable to help you, you've got that other person who can do it.
Okay. But did they all have to agree?
It depends on how it's drafted.
Okay.
The way I draft it, no. I draft as either or, it can act individually. There are some lawyers who draft codes, and I can't speak for them. I do not find that a very efficient way of working it, because first of all, some financial institutions will not accept a co-fiduciary. They will not open an account. Right now, and this is a great example, we did a guardianship last week in Montgomery County, and I'll just say this. I said to the family beforehand, I'm going to recommend you only do the sister and not the sister and her husband, because some banks will give you grief. And at the hearing, the incapacitated lady, who was quite articulate and verbal, but very poor judgment, said, I want my brother-in-law to do it. My sister, I love her, but he's better with the checks. And I said, okay, we'll do that. And then about 2 days later, I get a call from the brother-in-law. The bank won't open an account for us because they won't have co-guardians. They will only do one.
Okay.
So co-fiduciaries can be a challenge because here's why. 30 years ago, not an issue. With online banking, if you have to have everybody agree to a certain transaction, sign the checks and all, with online banking, one of them can go online and do something without the approval of the other person. So banks are basically saying, we don't want the liability of saying that everything had to be done jointly when somebody could theoretically go online and do something individually without the approval of the other co-fiduciary.
Okay, thank you.
You're welcome. So, I hope that I've made it clear why it's so important to have a well-drafted, properly legal, comprehensive, durable power of attorney. Let's talk about basic estate planning, okay? How does a will control the disposition of your IRA? Does anybody know? Not Carl, because I know he knows the answer. He's heard it 1,000 times. Come on, someone.
Based on beneficiaries?
Okay, so we got a will and we got an IRA. We got an IRA that says, I give my estate equally to my 2 children.
We don't have
but
audio. Oh, boy.
But I actually have 3 children, and my will leaves my stuff to 3 children. Who's the boss? The will or Terry? What do you want to say? You got to turn on you got to unmute yourself. You just muted yourself again, Terry.
You on mute.
No, we're on mute.
The IRA takes precedence.
Yeah, the IRA, my understanding, the IRA winds up the government. Like I have my IRA set with my beneficiaries. The government will not supposedly let them take it. They have to take it in disbursements, but it has to be completely removed within 10 years, is how I understand it.
Well, they can take it immediately if they want to, but they have up to 10 years to delay it. But that's really not the question I'm answering is this, Terry. Let's say your will says I give everything equally to my 3 kids, and your IRA beneficiary says I leave everything equally to 2 of my 3 kids. Is the will going to overrule the IRA beneficiary designation?
No.
No.
Okay. No, thank you, Gregory. Appreciate that. In fact, that's true. People need to understand that it's very important that you've got to make sure that if you want everything in your estate plan to be consistent, you've got to make sure that happens, because the will is only going to control what are called probate assets. These are assets that do not have a beneficiary listed on them. Anything with a beneficiary listed is going to pass per the beneficiary designation. And that's the point I was trying to make, that when we're doing planning, I have to make sure that I always remind clients, because today, many clients, their largest assets are their retirement plan, their tax qualified 401k, 403b, TIA-CREF annuity, whatever it is. That's often the largest asset that my clients have. And as a result, sometimes there's glitches. Sometimes there's computer problems. Sometimes you're sitting with the individual who's helping you fill it out, and that individual fills it out incorrectly. And you want to make sure that your beneficiary designations are consistent with the rest of your estate plan. Now, I'm also going to tell you something else here today that you're going to, it will be inconsistent with sometimes what you hear from the bank or the financial institution. So I will bet that at least a couple people here, the bank said, well, why don't we name your son or daughter or whoever beneficiary on your bank account, right? Somebody go like this. This has happened, right?
Sure.
Or they say your investment advisor says, we'll name your children as pay on death beneficiary of your stock account, right? We've seen that too.
Mm-hmm.
I'm going to tell you that that is not the best choice. And you're going to say, but Rob, that's fast. It is fast, okay? But when you name a beneficiary, there are no protections for that. So let's say upon your death, your son is going through personal bankruptcy. He's going to get a gift from your direct beneficiary, right? He's going to get that money pretty immediately. All he's got to do is bring a death certificate to the bank. And if he's the beneficiary, he's going to get all that money right now. And if he's going through bankruptcy, what's going to happen to that money?
Going to go to his bankruptcy.
Uh-huh. Exactly, Terry. It's going to go to his creditors. As a parent, is that what you would want? No. Every well-drafted will has a provision called the spendthrift provision. It gives the executor the discretion that if one of the beneficiaries is having this type of problem during or at the time that the estate will be distributed, that they can withhold the distribution until that problem has resolved. So let's say your son is going through bankruptcy. The executor could hold his distribution until his bankruptcy has been discharged, which means that your intent will be better carried out. But if you just leave a beneficiary designation, that's not going to happen. What if at the time there are issues with marriage and the money is theoretically distributed to a marital account and the ex-spouse is going after this money, which you never intended? So having a will or a trust in place for everything but tax qualified assets, because with tax qualified assets, that 10-year stretch that Terry described is a benefit because it reduces the overall potential taxation, because you might be getting it in smaller pieces and therefore it will add less to your taxable income in any given year for the beneficiary. So I'm talking to a large group of people, and obviously everybody has different facts and different needs. But my general advice to clients is to be very careful before you name people as direct beneficiaries of non-tax qualified assets, because you could end up putting them at risk and your wishes may not be carried out the way you intended them because of that. Okay? Now let's talk about the stuff that I deal with every single day, all day, 24/7, 365. What is the average cost of a nursing home in Southeastern Pennsylvania per month? And since we have like 3 screens of people, Jules and Ruth, why don't you tell me?
For a nice one like Sunrise, it's about $10,000 a month. If they're
Well, actually, I'm talking about nursing homes. Sunrise is what's called personal care. So I'm looking at the most expensive, highest cost, highest acuity level of care.
All right. Well, at least $10,000 a month, I would say then.
Okay. Okay. That's one. Anybody disagree for nursing homes? Okay, Mindy, you put your thumbs up, and we all know that you're in the business. Turn on your music, turn on demute yourself and tell me what you think, Mindy.
15,000.
Okay, Mindy says 15. Anybody got a difference? Dispenna, you agree with Mindy? Okay. So in our area, I generally see the cost of a nursing home as roughly 12 to 17,000 a month in 2022. It is an outlier, but a couple of weeks ago, I had a client tell me about a regular nursing home that was $880 a day. The only nursing homes that I know of that are that expensive are specific to people with traumatic brain injury and are ventilator dependent. There's only a few of them. Those are the only other facilities, but there was one in Chester County that was charging $880 per day private pay. I nearly fell off my chair because normally what I see is somewhere between about $375 and about $525 per day generally. But the numbers are outstandingly high if that isn't clear. Unless you're an extraordinarily wealthy person, having both spouses need nursing care or both partners need nursing care is a $30,000 plus a month obligation, which very few people have the funds to handle out of income. Okay, so let's talk about, how we deal with nursing care and paying for it. What is Medicaid and how does it differ from Medicare? Does anybody want to take that one on? I know it's a big mouthful. Jules, do you want to say something?
Well, Medicaid is for the poor, Medicare is for the elderly.
Okay. Yes and no.
Right.
Medicaid in general is what's called a means tested program, which means that yes, because it's means tested, they're going to look at your financial resources. But I'm really looking at what they pay for and what they don't pay for. And Medicaid has two different benefits, but we'll go into that in a second. So, but in addition to Medicaid being for the elderly, meaning 65 or over, I'm sorry, Medicare, I apologize. In addition to Medicare being age tested, it is not means tested, meaning anyone who has paid into the system over their working life is entitled to Medicare at age 65, but also it is a benefit for people who are considered to be disabled under federal law for at least 2 years. So if you are disabled and you're getting SSI or SSDI, more likely SSDI, you will also be entitled to get Medicare before the age of 65. Okay. The more important for my population question is, what do they pay for as far as long-term care? So how much does Medicare pay for a nursing home? How much will they pay for it? And I know I got so many people here. So if anybody wants to say something, anybody? Ginny,
Look
Natalie,
at Terry's hand. Terry's
what do you want
has
to
her
say,
hand up.
Mindy? Oh, you muted yourself again.
Terry has her hand up right there. She was, yeah, I don't know if you can see her, but Terry's been.
Oh,
trying
Terry's
to
got her
have
hand up. Well, Terry, unmute yourself and tell me what you think.
I am unmuted.
Okay.
Medicare does not pay for nursing home.
None?
Medicare pays for medical issues. So if you've got a drug program through Medicare, your drugs will be paid. But it does not pay for the care in a nursing home unless you are there for physical therapy rehabilitation services.
Ah, Terry, I couldn't have asked for a more beautiful answer. Thank you so much. So Medicare does not pay for what we call custodial care. So there's two parts in most nursing homes. There is the rehabilitation unit, where someone who has had a Medicare covered health event, like an injury, like a broken hip or a stroke, can go to a nursing home and get care covered by Medicare. But for how long? Do you know that, Terry?
Usually not more than 60 days. Most often it's not more than 14 to 30 days.
Almost
Depends.
100% there. I'll give you like a 93. So it's still an A. So here's the way the Medicare rehab Part A, this is from your Part A hospital coverage. So first, let's figure out the trigger, because there is a trigger before you're actually allowed to get that. First, you have to be admitted to a hospital as an inpatient for three midnights.
days.
Okay. So let's talk about that. Has anybody here ever heard the term observation status?
Yeah.
Okay. So when you are an inpatient in the hospital, you are considered paid for by Part A. That is your Medicare hospital benefit. If you are on observation status, you are paid for by Medicare Part B, which is outpatient services. The hospital doesn't always clarify this, and it's a very, very, very important thing that you have to advocate for yourself. Because if you are treated as an inpatient and you have those 3 midnights, you are good. Medicare will then pay for up to, well, they'll pay 100% of the first 20 days for skilled rehab in a nursing home. And then from days 21 to day 100, they will pay everything but a copay, which I think is $185 a day right now, $185 a day. What Terry was thinking about, which is great that you even knew this, but it was a little confusing. So your 100 days of Medicare rehabilitation replenishes after 60 days of no rehab. So if you're in the hospital and you use up, you're in the nursing home and you use up your full 100 days, and then you are not in need of skilled rehab for 60 days, and then go back into the hospital, your whole 100 days is now replenished. That's the 60-day number. But Medicare will pay for up to 100 days or a portion of up to 100 days if you're getting clinically helpful, beneficial care. They will knock you out in 14 days, like Terry said, if they don't think you're benefiting from the rehab. And nursing homes are afraid of Medicare. Just know that. Okay. So that assumes, though, that you are an inpatient. When you are under observation, you are in the same bed, eating the same food, getting treated by the same doctors, nurses, and aides, and the same janitors are cleaning your room, as if you are under Medicare Part A, inpatient. But that kicker is extremely important, because if you are 3 midnights under Part B as an observation patient, they're not going to pay. Medicare isn't going to pay. If you're under there 2 nights and they flip you to an inpatient, sorry, as long as you're not 3 nights inpatient, you are not getting Medicare to pay for your coverage. Now, this has gone through the court system a number of times. A recent court case came down allowing some level of appeal rights on Medicare Part B versus Part A. It's not been formalized by CMS yet, but there's a case that recently came down saying people have to know, and the law changed a number of years ago where you have to be alerted that you are Medicare Part A or Medicare Part B, meaning that you're inpatient or observation. But a lot of people don't understand it. And it's very important from an advocacy perspective, because if you don't have those 3 midnights, you're not getting Medicare paid for rehabilitation. And then you're out of pocket if you need nursing care inpatient in a nursing home. So it's very important that you do that.
But you have an appointment.
Sorry about that, guys. My reminder reminded me.
What about Part C?
I'm sorry?
Can you talk about Part C of Medicare in relation to that?
I'm not an expert on Part C. I'll be very honest.
Okay.
Is that like one of the Advantage plans?
Yeah.
Okay. So Advantage plans are under their own rules. So you do have appeal rights within the Advantage plans, but they are not following precisely the same rules as Medicare and a Medicare supplement that you would have. Oh, and by the way, I should have said that with most Medicare supplements, which is what most people have, that $185 a day copay for days 21 to 100 are usually, not always, but usually picked up by the coverage. And theoretically, although it rarely occurs, the Advantage plans are not restricted to paying for 100 days. They might say, we'll actually pay for your rehab in excess of what Medicare's rules say, but it's rare that managed care is going to be more generous than the federal government.
What?
Okay, so we know that if we're looking at someone who needs long-term custodial care in the other side of the nursing home, not the rehab side, but the side where people are simply older and frail and just need assistance with normal, what they call activities of daily living, which is feeding, bathing, dressing, ambulating, and toileting. Those are the 5 typical activities of daily living. So when you are in that section of the nursing home, Medicare will not under any circumstances pay for that care. So that's where Medicaid might be a consideration. So Medicaid actually has 2 separate programs. The the program that Jules mentioned earlier, where we talk about poor people, is that Medicaid, because it's a means tested program, will be limited to people who have very modest income and financial resources. That's for the health insurance program. That health insurance program is for typically younger families who need some assistance, and will cover both the adults and the children in the family. And also, by the way, it's far more comprehensive than Medicare's coverage because it includes vision and dental. The Medicaid that I deal with as an elder law attorney is typically what we call the Medicaid long-term care benefit. In the 60s, I think it was, the federal government said, it's really inhumane to kick out a 95-year-old lady when she runs out of money, kick her out of that nursing home. So Medicaid will come in, and if she meets the financial requirements and the clinical requirements, then Medicaid's long-term care benefit will pay for the care in the nursing home. Now, it's important that people understand that it's not just for people who have little money. They have to be clinically in need of the type of care that a nursing home is providing. That definition is called NFCE, Nursing Facility Clinically Eligible. So when we do a Medicaid application, we have to get a determination from the doctor, typically, that the person is NFCE, and that's part of the Medicaid application when we're seeking nursing home benefits. And I will just, make a side note here that even though the federal statute says that the long-term care benefit under Medicaid is only to be used for nursing homes, most states, including Pennsylvania, have applied for a waiver under federal law. So the waiver, which was what we call the program in PA, the waiver program will provide some, not 24-hour care, but a significant amount of care outside of a nursing home. So as long as you meet the clinical requirements that you need that level of care and you meet the financial requirements, you can actually get services through the Medicaid waiver program in your home. And those services are fairly expansive. It can include
Nice.
It can include a home care aide. Typically what I see is 2 to 10 hours a day, but I've seen more. They won't pay for 24/7, but oftentimes when we're looking at the waiver program, we're looking at someone who has some level of a support system. They have a spouse or some kids who can fill in, or they don't need quite 24-hour supervision, but they do need physical assistance. So they can do that. They can also include home modifications. So let's say you live in a home where you might need a stair lift. Medicaid could pay for that through the program. You might need grab bars in the bathroom, the commode or in the shower. Medicaid's waiver program could pay for that in the home. So it's a very expansive program. I will be very honest with you that right now, due to the COVID pandemic, even though we're getting a lot of people approved for waiver benefits, we're finding challenges in actually getting staffing to service these people who need the help. So I can get you approved, but the only way you're going to get the help is for there to be a home care agency that is approved with Medicaid that actually is willing to do it, because the reimbursement through Medicaid is far lower than what they would charge a private client. So just so you'd be aware of that fact. Waiver is a wonderful program and it works for many people. It doesn't work for everybody. Some people need 24-hour care, or they prefer the socialization of a community. But the waiver program can be very helpful for those people who fit for it. Okay, so I think I probably clarified why that is significant for the average older adult. We all have to think that unless you are a billionaire, you're going to need to find a way to finance your long-term care. And the numbers say, that about 70% of us or more are going to need some significant amount of long-term care before we die. It doesn't mean that everybody's going to need 24-hour care for 10 years, but it might mean you might need 6 months of care or whatever. Some people never need any care. But today, given the fact that many people are living much longer, they are in the minority. Most people need some help. The 85 plus population is the fastest growing population in the United States. And that population, simply because of age, has an incidence of some level of cognitive decline in 50% of the people who are 85 and older. So just by the numbers, all of us, many of us are probably going to need some level of assistance at some point in our life. So it's always a good idea to think ahead and rather than dealing with crisis. Although I will tell you, a lot of my waking and frankly sleeping hours are dealing with other people's crises, and we do it and we're happy to do it. But people, I think, as a general rule, would prefer to think ahead and not be in crisis or limit the crisis. Okay, so how do you qualify for Medicaid if you're going to a nursing home? Well, you have to spend down your resources. So if you are an individual with no spouse, you will have no more than $8,000 and protected resources to get Medicaid. So protected resource might be your primary residence, your home, a vehicle, a prepaid burial reserve, and that's limited. It's very limited beyond those items. Now, if you have a healthy spouse and they need to be maintained in the community, there's a lot more planning tools where I could actually supercharge the amount of money and resources, financial resources that the healthy spouse can keep so that they are not made destitute. But the important thing that people need to know is that if you are going to need this care, you will be harming yourself not to have a professional help you with the planning process. The cost of the professional will be far, far less than blowing through your entire life savings and giving it, to the care providers. I'm not saying they shouldn't be paid. They absolutely should. They provide a very valuable service. But as a practical matter, if you're my average client, my middle class client, a house worth of $300,000-$400,000 and maybe another $300,000 or $400,000 in assets, what we do is help you preserve the vast majority of that for the healthy spouse rather than blowing through all of it for care. And understand that, and we'll talk about it. Well, that's our next question. So let's go there. And Mindy and Lori can't answer this question. How do you get help paying for assisted living or personal care? Somebody mentioned the Sunrise. I think it was Ruth Mermelstein. Yeah. So how do you get help paying for a Sunrise or a Brandywine or a 5-star? Sarah, why don't you tell me what you think?
I think it's long-term health insurance.
So you're saying, Sarah, plan ahead. But how about the government? Are they going to help you with personal care?
I don't know.
Oh, Sarah. Okay, Terry. That's okay. That's a good answer, by the way.
If you or a spouse has been in the service, the Veterans Administration will help, again, meeting certain financial issues.
Right. Very good, Terry. Yes. So there is one program out there that may help you. It won't pay for the full cost of care, but the Veterans Aid and Attendance Program is a viable alternative for someone who is a member of the armed forces for at least 90 days, was discharged honorably, and at least one of those 90 days was during a conflict, a declared conflict like the Korean War, the Vietnam War, Desert Storm. So as long as you were at least a member for one day during one of the conflicts and you were honorably discharged, and you meet, as Terry stated, the financial qualifications. And again, they don't use the same NFCE requirement. They use a calculation based on how much care you're actually using. You can get that. But for those of us who are not veterans, and unfortunately, the vast majority of my clients are not veterans. Yes, Terry.
It also goes for the spouse.
Yes, it can be used for the spouse, although the benefit is slightly smaller for the spouse, and it can be used for a surviving spouse. So the veteran does not have to be alive. However, if you have divorced a veteran, you will not get access to the Aid and Attendance Program. And the Aid and Attendance Program is both usable for home care, but also is used for people who go to personal care facilities and assisted livings, because Medicaid will not pay for that. My roundabout point was that Medicaid will only pay for nursing home care in Pennsylvania or the home and community-based services through the waiver program, but they will not pay for buildings that are classified as assisted living or personal care. Interesting question. How much money can you give away in 1 year and not affect your Medicaid application? Stop smiling, Carl. You know the answer. How much, Terry?
I don't know the amount, but isn't it a 3 to 5 year look back on that Medicaid does? Oh,
You're
I'm
messing up my
sorry.
thing here, Terry.
I'm sorry.
It's okay. Anybody want to give me an idea? How about Pam Walsh? You got something to say, Pam? How about Marissa? Okay. Nobody?
0?
Who said that?
No.
Yes, you're right, Marissa. It's
Really?
0. So there's a lot of confusion out there. A lot of people think that the $15,000 a year allowable gift under federal estate and gift tax applies to Medicaid. It does not. If you happen to be one of those rare people who has an estate between $12 and $24 million, if you give away money of $15,000 a year per person or less per person, it will not affect your lifetime exemption of $12 to $24 million. For most of my clients, that is not a relevant term. For Medicaid purposes, there is no allowable gift amount, meaning any gift you make could potentially cause a reduction or penalty in your eligibility for Medicaid for up to 5 years after the transfer, or at least 5 years after the transfer, I should say. So there is a 5-year look back when you apply for Medicaid home and community-based services or nursing home services, where Medicaid is going to look at your whole financial picture, all your bank accounts, all your investment accounts, your life insurance, your annuities, any checks written for that 5-year period when you apply. And if they see something that looks like a large cash transaction, they're going to question it. If they see a check to your granddaughter for $35,000 to pay for her wedding, you're going to have a problem. It's going to create a penalty. They apply. Yes, Lori.
So I just had a question for you, because I just had a client who was on Medicaid and then an uncle passed away and left them their house or something, assets from a house. What happens then?
Okay. So interestingly, if it's a house, that's a unique asset, Lori, because a house could be considered a protected resource, even if you're on Medicaid. So if you're in a nursing home on Medicaid and she gets a house and she doesn't have another house, I would say no harm, no foul, but somebody's going to have to pay the taxes and upkeep on the house. If, however, Lori, she got, say, $250,000 as like a cash gift from her uncle and she's on Medicaid, she's going to lose her eligibility, because then she's got to go through
And
the whole
will she
spin
have
down
to pay it? Will she have to pay it back as well? Or no?
Medicaid payback or estate recovery doesn't apply until you're dead.
Okay.
And you have to be over 55. So if you're a younger disabled person who received Medicaid services and dies at 50, there is no estate recovery. But most of my clients,
Sorry to interrupt, but you have an appointment soon.
sorry about that, guys. My very eager database always likes to remind me. So yes, if you are on Medicaid and you receive money, that could make you ineligible. However, if you are a spouse of a Medicaid recipient and you receive the inheritance, that is not touchable, because once the ill spouse or the applicant spouse is approved for Medicaid, the two spouses are separated under federal law. They're considered separate. They're no longer considered spouses for purposes of Medicaid anymore. So as long as that spouse doesn't transfer any of that money into the Medicaid applicant's name, that would be safe. But if the Medicaid applicant receives that inheritance, they're going to be more likely than not removed from Medicaid. Now, there are times when, Lori, I can work with the department's legal counsel to avoid the removal. For instance, let's say that the person gets a $50,000 inheritance, but they've been on Medicaid for 2 years. So Medicaid has already paid $150,000 for their care. I can work with the department to do what's called a prepayment in anticipation of death, so that we'll give the $50,000 to Medicaid. They'll reduce the ultimate Medicaid lien and they'll keep them there rather than forcing us to redo the application process. So that can be done, but it depends. I have recently had a situation where the person didn't have enough owed to Medicaid to do that, and therefore they had to go off Medicaid when their husband passed away, and they got a certain portion of his estate by law. And unfortunately, the amount that they owed Medicaid was less than the amount that they were getting from their husband's estate. And she had to go off Medicaid. We're going to have to reapply in about 3 months. So we know that the government isn't going to pay for assisted living or personal care. And we know that you can't give any money away without it potentially, not always, but potentially affecting your Medicaid application. And how do they assess this penalty? Just so you understand. They basically say that in Pennsylvania, they come up with an average daily cost of care of nursing home across the state. Interestingly, that number skyrocketed between 21 and 22. Last year, that divisor was $364 a day as the average cost of care for all the nursing homes in Pennsylvania. This year, the divisor is $480 a day. So it's gone up like a third in 1 year. I've never in 30 years of practice seen that. But apparently, nursing homes have so much raised their daily rates that divisor. So for people actually making gifts, that's a good thing, because it reduces the length of the penalty. The penalty is divided by the average daily cost of care. So let's say that I gave Mindy $48,000, and then 3 months later, I had no more money and I applied for Medicaid. From the date of eligibility, but for that gift, I now have 100 days of ineligibility. So let's say March 15th, in December, I gave Mindy the 48 grand and I spent all my money. And March 15th, I am otherwise eligible for Medicaid, but for the fact that I gave her that 48 grand, meaning I'm under $8,000. I don't have any more money to pay for the nursing home. Now, Medicaid is going to say, okay, you are eligible, but we are going to hold off your eligibility for 100 days because you gave Mindy that 48 grand. And how does one pay for their nursing care during that ineligibility period? I don't know, but it's a problem. So if you are someone above the age of 60 and you're thinking about potentially gifting money to family members, you might want to think about that in terms of your overall estate and elder care plan, because you could end up doing something that could be harmful to you. As much as what you're trying to do is probably a loving and caring expression, you could end up being in a bad position later. And I hate to say this, but it's out. Yes, Terry.
I have a question for you.
Mhm.
I currently no longer live in the state of Pennsylvania, but children are going to have me come back home because I am now a widow.
Okay.
So I'm going to be coming back to Pennsylvania soon. When I do come back to Pennsylvania, my thought patterns to attempt to maneuver around all these issues was to put my new home in both my name and one of my children's names, like you would do with spouses, so that half the home would be on paper owned by that other person.
That is a
possible?
presentation in and of itself, Terry.
But is that possible?
It's legally possible, but it could cause you a Medicaid issue. I mean, when you give a half, if you're buying a property worth $300,000 and you put your son's name on it, you just made a gift to him of $150,000.
Oh my God.
I did not ask for that, but it was perfectly timed. So, Terry, there are some risks to doing that. I will give you a few. Number one, what I just said to you, the Medicaid risk, because you are now making a gift of half the value of the home. Number two, if your son passes away before you do, you're actually going to pay inheritance tax on your own house.
Why? I didn't pay inheritance tax on my house from my husband.
Well, but your son would have died and you would have inherited his half of the house.
So a child is different than a husband or wife?
Absolutely.
Yes.
A spouse, there's no tax on transfers to spouses, but a parent to child or child to parent spouse is taxed at 4.5%. So if you had a $300,000 house, 150 of which you gave to your son, and then he passed away and you re-inherited it, you're looking at a $7,000 potential.
I didn't realize that they thought it was an inheritance.
Well,
I mean,
again,
how
I'm
do
hoping
they-
your
how
son
do
doesn't
they
die
prove
before
that-
you do. I'm just telling you, talking about contingencies. Another thing, remember I talked about creditors before. Well, you name your son as a half owner of your house and he gets into a car accident and someone gets $1 million judgment against him. Guess whose house they're coming after? So I'm not saying you shouldn't do it. I'm saying you should talk to somebody who can give you the full picture of the positive and the negative before you make a decision that could ultimately have both positive and negative consequences for you as well as your son.
Okay,
Okay.
thank you.
So we've already talked about the next question, and that was we were discussing the 5-year look back for Medicaid eligibility and Medicaid applications. So you've got to think that the financial transactions you might make today can affect you for a significant period in the future. If your spouse goes into the nursing home, how much will you be able to protect? Well, as we mentioned before, the primary residence, a vehicle of no particular value, you could buy a new car, a couple of burial reserves. Every county has a different maximum for burial reserves. I don't know why, but Chester County is very expensive to die in because Chester County's burial reserve number is like the highest by a large margin. Like Montgo went up a lot over the last couple of years, and it's $23,000 per burial reserve for husband and wife. Chester is 30 grand, whereas Philadelphia is 17.5. So I don't know what they do in Chester County when they're burying people, but boy, is it expensive. So just be aware that each county, when you're applying for Medicaid, it's going to be the county in which the nursing home is located or your home is located if you're seeking waiver services that's going to determine how much you could put into a burial reserve. But assume that the minimum in this area is going to be at least $15,000 per person, which, while not generous, is adequate for a basic funeral. And frankly, a lot of my clients today are setting up cremation, which is much less expensive. But you have the burial reserves, you have the house, you have the car, and you have protected resources up to, depending upon how much other assets you have, up to $137,000 for the community spouse. That's it. And for Southeastern Pennsylvania, if the healthy spouse is 60s or 70s, $137,000 is not really a huge cushion long term. So it is a worthwhile investment of time and money to do the planning and be able to maximize those resources that you have. And again, some people have multiple millions of dollars. Medicaid will never be an issue, but the vast majority of the population is not in that position and therefore should be thinking about what they do is going to affect them later and thinking about the type of care they want, how they want it, where they want it, and think ahead. And just like anything else in life, look, every thoughtful person who wanted to prepare for retirement started saving when they were young, right? They put money in their IRA, their 401k, they saved outside of their 401k, whatever they did. If you're thinking, and again, the likelihood is all of us are going to need some level of care, assistance, then you really need to get a plan in place. That plan for some people, Sarah, is going to be long-term care insurance. Unfortunately, long-term care insurance is not the same as it was. When I was a young lawyer in 1992, when I came out of law school, long-term care insurance, first of all, there were at least 50 to 100 insurance companies that actually sold that policy in Pennsylvania. Today, there's about 7. Back then, when I would do a cost-benefit analysis, it was very easy to recommend because the cost of the plans were so low in comparison to the potential benefits that they would pay that for even people of relatively modest wealth, I was recommending long-term care insurance. Today, because they've had such terrible experiences with long-term care insurance, most companies don't sell it anymore. And the companies that do sell it, the cost is exponentially higher. So I'm 56, just had my birthday last week, guys. I'm 56. For me to buy a policy that I would want, that I would think would provide the kind of care and the cost, I'm looking at least $5,000 a year for me and $5,000 for my wife, who's of similar age, to get a good policy. Okay, so discussion then comes, how comfortable are you with your own investment skills? In other words, is it better for some people to just say, I'll put $10,000 in an investment, in a low-cost mutual fund and see if in 30 years when I might actually need it, I got enough money to help pay for care. It may not give you exactly the same benefit, but if you do well, it's not going to be as hard as far as it used to be. It used to be the cost of the insurance was far lower than trying to invest and save for yourself. Today, the numbers are much closer. I'm not saying long-term care insurance isn't a good choice. I'm saying it's a much harder choice to recommend than it used to be. So it's a fewer people would benefit from it. And once you get into your early 60s, the cost is going to be high. I have healthy people looking in their late 50s, and they're looking at 12 to 15,000 for a good policy for husband and wife. So it's great to have it, but you've got to consider the cost benefit analysis because it's a very different analysis than it used to be. Okay, it is now 3:07. Oh, wait. Cheryl, you had a question.
Yeah, I had a quick question. With long-term care planning, like I'm ineligible because I'm on disability. So I just decided.
When you say ineligible for what?
Long-term care.
Insurance, you're saying?
Long-term care planning.
Well, long-term care planning is a term that I use to describe how someone comes to me and I assess their health and their finances and make a plan. So you're not ineligible for that, but you may be ineligible to buy insurance because of your disability. Okay.
So what would you say? Because I just decided to save money instead.
Well, I would probably suggest, and again, this is not a commercial for me. Any good elder law attorney, you should have a sit down with that person and discuss with him or her your personal situation, and then they can help you assess and look at your finances and what your goals are and say, here's what I think you should do. Okay, so Cheryl, good example. Some people have no children, so they're not worried about preserving money for the next generation. Some people have kids that they want to make sure they leave a legacy to. So their planning is going to be very different. So what you need to do is find a professional who you have a very in-depth, detailed conversation about your priorities, your goals, your finances, and your health. And then they can help you say, well, here's what you can do. And here's what's going to be the ups and downs of these different scenarios and choices you make. Like any good plan.
Thank you, Rob.
You're very welcome.
Rob, I'm going to interrupt for one moment because I want to make sure that everybody that was on today gets to see our sponsors for today. We're very thankful for our sponsors who are offering raffle prizes, and I want to give them the floor for a moment, and then we can maybe have do you have to get
I'm done.
Okay.
I've done all the important stuff.
Okay, well, great. So if we have any small questions for Rob, maybe you can email them to me later. If he has to, do you have to get off, Rob? Okay.
Stay for a couple more minutes.
Okay. So we have Bernadette Bonner from Symphony Square in Ballackinwood, and we're going to give her a moment to speak. Thank you so much, Bernadette, for sponsoring our presentation today.
Thank you. And thank you, Rob. This was really wonderful and so useful. And thank you everyone else for joining. So Symphony Square is a personal care and memory support community. And like Heather said, we are located right here in Ballackinwood. So a great place for being able to really have the peace of mind of knowing that you have the support. So not the same as the skilled, but personal care similar to assisted living. So you have caregivers and that sort of stuff in the building and care plans. And then also the resident experience piece, so that social piece. And one of the things that we're doing that I'm so excited, if you don't mind me just announcing, is our Grateful Give Back. So it is our goal this year to achieve 2022 collective acts of goodness. So it's great for everybody. It gives us a sense of belonging and really just spreading kindness, and kindness is contagious, and I think we need it. So we're doing lots of different things throughout the year. And if you want to learn more and help, certainly reach out. I know next month is all about our furry friends, the animals, and helping out animal rescue. So our residents and the community and our staff, families are all getting involved. So reach out if you need anything. And thank you again, Rob. This was a wonderful presentation.
And thank you for your efforts in getting all these fine people in the room.
Thank you. And Bernadette's raffle winner is Raquel Stewart. Yay. So we'll make sure that we get information to each of you. And then we have our next sponsor. We have Mindy Muzenter from Senior Living Specialist, as well as a few other ladies are on here, Lori Bernstein, and also Desi Boston from Senior Living Specialist. And I'm going to allow Mindy to say a couple words here.
Hi, everyone. Thank you, Rob, for this. Has been terrific. And thank you again for assimilating all these wonderful people to listen to this. We are senior living specialists, and we are 3 women who try and help people find their next home, whether it be personal care, memory care, independent living. We are complimentary service to families to help find their next home when they're ready to move. We also are just a great resource out there in the community for anybody that might have a question or two that's not legal, because we don't know that, but any question or two about referrals or things that they might need to have questions on, please feel free to reach out to us. And thank you again. And who is our winner?
Your winner is Cheryl T. Congratulations, Cheryl. Thank you. And then our other sponsor today was Brett Wiley from Fox Rehab. Unfortunately, Brett had to hop off, but I will share with you that Fox Rehab does an amazing job with providing in-home services for PT, some physical therapy, occupational therapy, speech therapy, and they'll come right into your home to assist with those needs. They are available throughout the 5 counties as well in Southeastern Pennsylvania, same 5 counties that I should mention that we cover, as well as senior living specialists, Montgomery County, Chester County, Delaware County, Bucks, and Philadelphia counties. And of course, we know that Symphony Square is located in Montgomery County. So thank you so much. And the winner for the Fox Rehab Wawa gift card is Elaine Dewan. So we'll be sure to reach out to Elaine. Thank you again to our sponsors. Bernadette, did you have something that you wanted to add?
I did, if you don't mind, if I could
Yes.
just say, just adding on to Fox Rehab, they come here as well, and I can attest, they are incredible, and our residents, families, and everyone love our staff. They love them. They always participate in everything, and they have such huge success stories. So I'll attest to that.
And don't you like us too?
I love Mindy,
Okay,
Lori.
there it is.
They're
I just had to make
wonderful.
sure.
I do. Sorry, they're wonderful. Super
Thank
helpful.
you so much. And we are happy at Slutsky Elder Law to help you with also finding additional care services that you are in need of for you and your family, or any of your neighbors. We're happy to be a resource to you. As a follow-up to you, I will be sending out an email. It will have everybody's contact information from our sponsors' contact information, as well as some information about our office and our team at Slutsky Elder Law. Thank you so much for joining us today. I appreciate you staying on a little bit after 3, and you were great listeners, and I hope that you learned a lot of information today.
Thank you.
Thank you.
Thanks
Good to
again,
see you all.
everybody.
Thank
Bye-bye.
you.
Thank
And we
you.
will be adding your name to our email distribution list, so you can look out for our newsletter with any upcoming presentations that we have on additional topics of interest.
Thank you.
Thank you.
Heather.
Thank you, everybody. Reach out anytime.
Thank you.